Yes, yes.
AJ, if you could just sum up for us what your arguments today before the judge was.
Well,
in this matter.
it's a large number of issues that I dealt with today. I summarized our submissions numbering a large number of pages. So anyhow, so first of all, I made the point that the proceedings which have been filed by the GTU through its lawyers are defective and I believe incurably defective. The many issues that they have argued upon and they have submitted law in relation to are not part of their pleadings. Now, a lawyer must set out his or her pleadings, and then the case is based upon that. It is the pleadings filed that is used by the other side to file their defense, and then you write submissions based on those pleadings. So the pleadings were defective. For example, there is no relief there in the proceedings that seek to get money for striking workers. There is nothing in the pleadings that speak to collective bargaining. And a host of other things have not been pleaded, but you have heard arguments on. So the pleadings are defective, and I invited the judge to consider what he can do in face of that type of defective pleadings. Then secondly, I dealt with the principles, although they were not pleaded, because they were raised in the argument by the other side. I believe that I demonstrated with great clarity, examining the Constitution, the 1966 Constitution, the 1980 Constitution, the 2001 Constitution, and all the changes that have taken place in relation to trade unions and in relation to rights to strike and freedom to strike, that there is no right to strike in Guyana, there is a freedom to strike. That's an important thing. The Constitution has a right to demonstrate, a right to assemble, but a freedom to strike. The draftsman using language differently, different language to portray a different concept. Then you have the right of the worker, of the employer. The Constitution also protects the employer's right to property. So how can you advocate that you have a right to pay when you have not worked? Because if you are to be paid for service not rendered, then you are compelling the employer to give you his property for which he has received no compensation and no reward. So that's the first, constitutionally, the concept can't fly. Secondly, labor. Wages is defined in the Labor Act. It is monies paid for work done or to be done. That is the definition of wages and salary, for work done or to be done. So how can you not do work and expect to get paid? I also examined other parts of the Constitution which they relied upon to show that no international treaty that we have signed in the ILO or anywhere else has conferred a right on a worker to get paid for work not done during strike period. So that concept, I believe, I rejected completely. Then the union dues matter. First of all, as an executive policy matter, the law of judicial review is clear. You have separation of powers. Matters that are within the remit of the executive cannot be reviewed by the court. And that is why in the GTU matter, for example, with Nandlall, they did not go for judicial review because the voluntary service of the government in offering this facility to the union is not grounded in contract, is not grounded in law. Is the government, as part of its policy, has decided to extend this service to the union. Voluntarily, and anything that is voluntarily being done can be terminated voluntarily. And the decision to do so is an executive decision. The same way that the court have repeatedly said in cases filed by very Royce Dilford that in relation to parliamentary business, that the court can't inquire into the business of the parliament. Similarly, the court can't inquire into the matters that are purely executive matters. These are beyond judicial review. If there is a decision that is wrong, and it's part of executive policy, well then the executive pays for that at election time. That's how the democratic process works. So this termination of union dues has they can't challenge that, and even if they challenge that, we have given a number of cases to show that there is no legitimate expectation for the government to continue paying, right? And then the other issue about what was taking place, whether collective bargaining, whether that the teachers and the union were engaged in the union and the ministry were engaged in collective bargaining. Now, as I've said before to you, there is no collective bargaining is not a principle of exactitude. It's not a science of precision. It is simply bargaining on behalf of a collective. And the union and the education ministry have been doing that since August 2020, since we assumed the government. Now, it was not done in the conventional way. It may not have been as successful as one of the parties may have wished. They may not have discussed all the matters that they should have, but that does not mean that there was no collective bargaining. Collective bargaining can be a loose, it can be an informal process. And in fact, out of this process, many benefits and policy measures, including financial matters, were discussed and implemented. Both sides accept that. It may not be the large number that the union felt should be. The union felt that salaries should have been included in the discussion. They were not, and that seemed to be the fact. But that doesn't negate the fact that even collective bargaining does not mean that you get everything that you want. It doesn't mean that you get to discuss everything that you want. And the union must accept responsibility for not pushing it further. Till 2020, they bargaining that they should have, but that does not mean that there was no collective bargaining. Collective bargaining can be a loose, it can be an informal process. And in fact, out of this process, many benefits and policy measures, including financial matters, were discussed and implemented. Both sides accept that. It may not be the large number that the union felt should be. The union felt that salaries should have been included in the discussion. They were not, and that seemed to be the fact. But that doesn't negate the fact that even collective bargaining does not mean that you get everything that you want. It doesn't mean that you get to discuss everything that you want. And the union must accept responsibility for not pushing it further. Till 2020, they're banging at the same door. And they're not getting through according to them. So what you keep going back to the meetings for? You have a 2019 agreement, 2018 agreement that expired. You want to enter into a new one. You put a 2019 agreement forward. And up to 2024, you have done nothing about it. And you're still going to the meetings. You're still taking benefits from the ministry. You're still negotiating. You're still asking for more benefits. So, I mean, you can't blow hot and cold. You have to accept that you yourself didn't push, perhaps in the way that you should. But you can't, after negotiating with the government, taking benefits and putting forward proposals, and those proposals are being accepted, and you accept them for your betterment, and then you want to say that you are not part of the process. It doesn't work like that. So all those issues were addressed. And
Hey, I just have one question. Regardless of how the judge will rule next week, whether you think that this entire case necessitates any change to the current status quo, or to put a structure in place for the whole talk about collective bargaining, whether you strike, whether you get paid.
My friend, there is a structure in place. Our laws in relation to collective bargaining mirrors the law in the Caribbean. We have all the protective mechanisms that are there.
And it's working.
Some countries have gone further. They have established an industrial court. They have other legislation in relation to that court. I don't know whether we want to go in that direction, whether we have the type of activism here, the type of work here for that type of infrastructure. But it's a matter for consultation and discussions. The constitutional amendment process, reform process has just begun. So anything that you want to put in the constitution, you have an opportunity to do so.
AG also commented that the union dues, if ruled by the judge, has far-reaching implications for the future. You were saying in a sense. Can you tell us how?
I was not talking necessarily about union dues. I was talking precisely about working or ruling that a worker is entitled to salary and wages when they have not performed the work. That will have serious implications in this country. and in every part of the world. There is no part of the world. You hear Mr. Ford, he went to India, he went all over the place, and the judge telling that is not a position in India. Of course, India has different legislation, you got to consider that. But you look at the whole of the continent of Africa, you look at North America, you look at Caribbean, the whole Commonwealth. There is no country that has a law that says workers can get paid for work not done. That is why, as the judge said from the bench, when you do the resumption, the terms of resumption, they always speak to whether the employer will agree to pay for the days that work were not done. There has to be an agreement. There has to be an agreement. You can't impose that on a worker, on an employer. All of you have employees, or you will get employees. You could imagine that the law is that your employee decides to stay home instead of striking, and you got to pay them for the day. What will happen to you?
Thank you.
Yeah.